Hello, my name is Amin. I go by Sam. I'm the principal attorney here at Amin Law in San Francisco, California. Today we will be discussing the Paycheck Protection Program, famously known as the PPP loan, or more commonly known in the criminal courts as the PPP fraud. We'll talk about what the government will have to prove in order to convict and the most common causes of action or crimes that are charged in court. We'll talk about the prospective punishments, and of course we'll talk about defenses. The Department of Justice, in coordination with a number of other federal investigative agencies, such as the IRS and the FBI, have been actively scrutinizing and investigating allegations of PPP fraud. Now you ask, what constitutes PPP loan fraud? Well, the following are some examples of actions that could result in criminal prosecutions for PPP loan fraud. Number one, using PPP funds for unauthorized purposes, such as personal expenses. Number two, making bad faith certification on your loan applications, for example, making a false statement. Number three, inflating payroll costs in order to receive a higher loan amount. Number four, obtaining funds from multiple lenders. Number five, firing or failing to rehire employees or cutting employee salaries despite receiving PPP funds. Number six, underestimating number of employees or misclassifying employees as independent contractors in order to qualify as a small business. And number seven, misrepresenting or concealing information during a PPP audit or fraud investigation. The Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act, does not explicitly contain provisions for criminal enforcement of the Paycheck Protection Program. As such, the Department of Justice has had to rely on pre-existing federal statutes in pursuing charges for PPP loan fraud. The following are some of the federal crimes that DOJ may pursue against those suspected of committing PPP loan fraud. Number one, bank fraud. That carries a maximum sentence of 30 years in prison and or a fine of up to $1 million. Number two, wire fraud. That carries a maximum prison sentence of 20 years or 30 years plus a maximum fine of up to $1 million if the violation affects a financial institution or involves any benefit associated with a presidentially declared major disaster or an emergency. Number three, mail fraud. That carries a maximum prison sentence of 20 years or 30 years plus a maximum fine of up to $1 million if the violation again affects the financial institution or involves any benefit associated with a presidentially declared major disaster or an emergency. Number four, making a false statement to the SBA or a financial institution such as a bank. That carries up to 30 years in prison and a fine of up to $1 million or both. Number five, making false statements to a federal agent. That carries a maximum sentence of 5 years in prison and or a fine. Number six, conspiracy to defraud the government. That carries a maximum sentence of 5 years in prison and or a fine. And finally, number seven, tax evasion. That carries up to 5 years in prison and or a fine of up to $1 million for an individual or $500,000 for a business. Defenses. Of course, each of the crimes I listed above will have a different set of potential defense or defenses. Nonetheless, if for example you're charged with wire fraud, some of the most common defenses include number one, lack of intent. For example, you have to specifically intend to commit wire fraud. And number two, mistake of fact. For example, if, in good faith, you thought the information furnished on, say, your application, loan application for that matter, was factually true, but it was in fact false, that would be a defense. Thank you for watching. I have a team of professionals who are ready to assist. All you have to do is pick up the phone and give us a call. If you found this video helpful, I'd greatly appreciate it if you can share it. Of course, don't forget to like, comment, and subscribe. Bye-bye.